Hello, everybody. Today I am going to discuss with you the important judgments of 2022. So I'll be starting with the judgment on plea bargaining. As I have already discussed about bargaining in one of my lectures. So when I talk about plea bargaining, I talk about chapter 21A of Criminal Procedure Code. So this is a famous judgment. Let me share a whiteboard with you and I'll write the name of the judgment. So first judgment is of it's like in the policy, strategy for grant of bail. Now, this judgment is of 2022. Here, the directions were issued by the Honorable Apex Court to the disposal of the cases, criminal cases by method of plea bargaining, compounding of offences, and under the probation of Offenders Act. This is a very important judgment, a landmark judgment. Next judgment, which I will be sharing with you, is of again 2022. So commercial courts is not in your syllabus, so I'll be not sharing the judgment on commercial courts. But yes, the subjects which are part of your judicial curriculum, I'll be sharing those judgments. Next judgment is on uh, again family law. So the name of the case is it's Ashima Ashima Ketrapal versus Dinesh Sethia. So here the directions were issued to the family courts as well as to the Laka magistrates, which are seized of FIR case. Proceedings under the Protection of Women from Domestic Violence Act to accommodate the respondent husband with a single data so that his appearance in all cases is not more than once in one calendar month. As and when all the matrimonial cases are so adjourned, when the cases are transferred to a court as requested by the wife. So basically, it emphasized because when the family litigation takes place, there are multifaceted litigations. You have proceedings under the Domestic Violence Act. Then one is also facing a FIR. So criminal litigation is also there. So basically, here the emphasis of the court was now this is a very landmark judgment of our own Punjab and Haryana High Court, where the emphasis was to give one date in all cases rather than harassing a person for different dates. Because at the end of the day, the cause of action is same. So instead of coming and wasting the time of the court also, it was deemed fit by this Honorable High Court of Punjab Haryana to lay down these conditions. So Ashima Khetrapal versus Dinesh Sethi is another important judgment. Next, I will refer is on section. So basically, here the court, the apex here, basically the apex court has summarized the directions, the duties and responsibilities of the trial court to deal with the aggrieved person in sexual offences before them in appropriate manner. So as we already discussed what are the parameters, what are the how the electronic evidence and the protection of vulnerable witnesses has to be dealt with in one of my lectures, which have been already posted in my YouTube channel. So this judgment again emphasizes on the same uh, note, especially regarding how to, the duties. The trial court is reminded of the duties how to deal with the uh, you know uh, persons victims of this heinous crime, right? So you can note down the judgment. So it's XYZ. As I have told you earlier, that in these offences, the name, the identity is always uh, it is the name, identity of the victim is always hidden for the interest of the welfare of that individual. So it is XYZ versus MP, state of MP. So these judgments you must all go through. These are very landmark judgments. The next judgment which I'm going to share with you is of uh, Section 389 CRPC. So what is Section 389 CRPC? So Section 389 of the CRPC is, let's all open our bare acts. So Section 389 of the CRPC says, suspension of a sentence pending the appeal release of appellant on bail. So basically, Section 389 talks about the suspension of sentence pending the appeal release of appellant on bail. So in this landmark case, write down the name of the case. It is Jagjit Singh versus State of Punjab. It is Jagjit Singh versus State of Punjab. State of Punjab. So here the accused that has been convicted and sentenced for various imprisonments. His sentence was suspended by the High Court during the pendency of the appeal, and consequently he was ordered to be released on bail forthwith on furnishing adequate personal surety bonds to the satisfaction of the learned uh, satisfaction of the learned uh, judicial magistrate. However, learned magistrate did not act upon the order passed by the High Court. It was observed that there was no reason for the chief judicial magistrate or duty magistrate, as the case may be, not to act upon the order of the court. In any case, there was any glaring ambiguity in the order passed by the High Court, the court concerned could have sought clarification in that record, and failing which there was inordinate delay in releasing of the accused, which is in clear violation of right of life as described by Article 21 of Constitution of India. Courts have to act upon the order, are required to be more sympathetic and considerable qua implementation of bail orders in letter and spirit so as to give speedy relief to the person concerned. So these were the clear guidelines for the duty magistrates or for these court magistrates who were given these instructions to follow the orders of the High Court in spirit. judgment which I want to share with you is Seva Singh versus Balwinder Kaur. Seva Singh versus Balwinder Kaur. Again, a landmark judgment. So here we are talking about Indian Evidence Act, especially sections 61 to 73 and 62 to 72 of Indian Evidence Act. So when we talk about these sections of Indian Evidence Act, so section 61 basically talks about uh, documentary. So this is under Chapter 5 of Indian Evidence Act. It talks about of documentary evidence. So section 61 talks about proof of contents of document. 62 talks about primary evidence. 63 talks about secondary evidence. Moving further, when I talk about 68 to 72 in particular, you remember these sections are particularly invoked, especially when we have to prove will. You know, when I say will, you should all remember that will is will has to be proved in the court of law. So there can be registered will also and unregistered will also. I will have a separate uh, lecture on will, how to prove it, which are the important provisions of Indian Succession Act, which to be read vis-a-vis Indian Evidence Act. What is the relevancy of a will? What are how court act in these matters? Because we normally say that in matters of will, since there is a lot of litigation, and I tend to do practice in this area in specific. So I have seen that courts sit as a testator and they always go with the evidence adduced, especially when we talk about how to prove a will. So, as requirement of Indian Succession Act, vis-a-vis Indian Evidence Act, it has to be proved by the testing witnesses. So, this judgment, that is Seva Singh versus Gurinder Kaur, uh, here it was held. Now, this is judgment of our own High Court, Punjab Honorable Punjab National High Court, where it was mentioned that there is no requirement that the original document must be kept in record file of the court. A single file of the court, it steps a single file of the court. It is sufficient to bring the original for the perusal of the court by the party, which can be examined and returned by the court while keeping its copy on record. So, if you see old RSA, especially, what is an RSA? RSA is a regular second appeal, and it is provided in Section 100 of Indian of Civil Procedure Code, where a substantial question of law is framed. So when I see, like, I have um, when I see old RSs, I've often seen that original documents like will or any original document like sale deed, they're normally attached in the court, on the court file. So this judgment clarifies that there is no need of keeping the original document with the court. It is only called by the trial court when there is examination and it is compared by the court. The original is seen by the court, and normally, after taking note of it, the tested copy is kept in the record of the court, and this is how they proceed. So it also protects the important documents. Uh, in case there is fire or there is misplacement of the file, which is very evident these days. So the original document is attained by the party itself, as and when needed. It is always shown in the court. So it was also held in this case that whenever the documents are exhibited in the evidence, the presiding judge is required to record as to whether the primary evidence has been produced or not. If a copy is placed on the file of the court, but the primary evidence is shown to the court for comparison, which on being examined is found correct, then there is no requirement of keeping the primary evidence in the court file. Wrong. It also further observed that a wrong practice established by the courts to adjourn the case for cross-examination, which not only results in wastage of the precious time of the court, but also causes inconveniences to the parties and to witnesses. It also held that the courts can preferably insist upon supply of a copy of the affidavit to other party a day or 2 days before the date fixed for evidence so as to grant sufficient opportunity to opposite counsel to come prepared for cross-examination. Moving further, I'll talk about one of the important landmark judgments of Punjab and Haryana, which is Amit Kumar versus State of Haryana versus State of Haryana. So this judgment in particular talks about 138 of Negotiable Instruments Act. So here the principles of law enumerated vis-a-vis section 389 CRPC and 148. So you must go through this judgment also. Moving further, I talk about uh, one of another important judgments by the Honorable uh, Supreme Court. So it is regarding uh, Order 20, Rule 18 of CPC. So when I talk about Order 20, Rule 18 of CPC, you all should be aware that I am talking here about that once preliminary decree is passed by the trial court, the court should proceed with the case of drawing the final decree. Now, what is preliminary decree? Preliminary decree is defined in CPC, right? So preliminary decree, you should know in which cases the preliminary decree is passed. For example, partition suits, right? We normally draw up a preliminary decree, then we file a, then the court passes a final decree. So all these differences, what is a decree, uh, what is a preliminary decree, what is a final decree, what is the difference between all of it, I will be discussing when we will have regular lectures of civil procedure, right? So you write down the name of the judgment. It is Katu Gandhi. It is Katu Gandhi versus it's Katu Gandhi Krishnan. Katu Gandhi Krishnan versus Katu Katu Gandhi Idhati. Edhil. So it pertains to Order 20, Rule 18 of the CPC. So detailed judgment has been passed. You all should be aware of the judgment. Moving further, I will talk about another important judgment of our own Honorable High Court of Punjab and Haryana. I talk about Section 309 of CRPC. So when I talk about Section 309 of CRPC, it is basically power to postpone or adjourn proceedings. So this is a very important section, 309. So Honorable Punjab and High Court have laid down the guidelines in this case, and they have relied on Rajesh Yadav versus State of UP. So here again we will talk about uh, the conditions which were created with regard to the examination of the witnesses. So in the view of the guidelines issued in this matter, the Honorable Punjab High Court passed guidelines for speedy trial and check delay of recording of prosecution evidence. So Section 309 CRPC talks about. So the name of the judgment is Jitendra versus Punjab, State of Punjab. Moving further, we talk about another important landmark judgment of Supreme Court, which in particularly pertains to Section 124E of Indian Penal Code. So, what is 128 of Indian Penal Code? 124A of the Indian Penal Code. So, when you see 124A of the Indian Penal Code, talk about it talks about basically criminal conspiracy. So, it talks about uh, 124A talks about sedition. So the sedition is basically talks now sedition. When we talk about 124A, it talks about the punishment for sedition. So here in this court, the directions were uh, so here in this court, the directions issued regarding dealing with cases under 120. So when I talk about 124A of IPC, I talk about sedition. So here the guidelines were laid down by the Supreme Court. It said if any fresh case is registered under 124A of Indian Penal Code, affected parties are to approach the concerned court for appropriate relief. The courts are requested to examine the relief sought, taking into account the present order passed by Honorable Supreme Court as well as clear stand taken by India. All pending trials, appeals, and proceedings in respect to the charges framed under 124A be kept in abeyance. Adjudication with respect to other sections, if any, could proceed if the courts are of the opinion that no prejudice would be would be caused to them. So the name of the judgment is write down is SG. So the name of the judgment is so the name of the judgment is S. Dot G. Dot Ram Bal versus Union of India. Then another important case was by the Honorable Supreme Court was in Re to issue certain guidelines regarding inadequacies and deficiencies in criminal trial. Now, here we talk about section 438 CRPC and 439 of CRPC. So when I talk about section 438 of CRPC and 439 of CRPC, we are basically talking about so basically it comes under provisions for bail and bail bonds. So basically we're talking about when we talk about this section 438, we talk about basically grant of bail, apprehending, arrest of person. And when we talk, so here the directions were laid down by the Honorable Supreme Court. and we'll talk about 439 special powers of High Court or Court of Sessions regarding bail. So here, the directions were issued by the Honorable Supreme Court with application for bail. The application for bail in non-bailable cases must ordinarily be disposed of within a period of 3 to 7 days from date of first hearing. If the application is not disposed of within such period, the presiding officer shall furnish reasons thereof in the order itself. Copy of the order and the reply of the bail application stated support by the police of prosecution if any shall be furnished to the police on the date of the pronouncement of the order itself. The bail order should be furnished by the prison, be furnished by the prison authority, the accused. So basically, these were the guidelines. Because normally, what was happening after the first hearing notice was issued, it used to take sometimes more than a month. This guideline came by the Honorable Supreme Court as a big relief to the people who are seeking basically for directions of the bail. Next judgment I am talking about is Kulwant Singh versus State of Punjab. Again, this reflects the directions issued by the uh, criminal issued to the criminal courts regarding the provision. So the judgment is Kulwant Singh versus Punjab. So here also I am talking about section 438 and 439 of Criminal Procedure Code. Here also the directions were given regarding the bail applications, vis-a-vis verification of parties. So this is another important judgment of 2000. So moving further, we will talk about uh, section 64 of CRPC. Now, what is section 64 of CRPC? We are talking about arrest. So here, important guidelines were issued by the. There are three judgments which I will highlight here. Sheila versus State of Maharashtra, Amrik Singh State of Punjab, Janki Prasad versus State of Haryana. So here, directions were issued for the magistrate. See, it's very important to remember that you also, when God willing, you become judicial officers, you will be adhering or you will be going through 1 year rigorous training. So all these what I am telling you information is very, very important and vital for you. It will be also helpful you understanding the basic fundamentals, the latest guidelines, because we always say the law of the Supreme, we say that the judgments of the Supreme Court, we always say that that is the law of the land by virtue of article, which article of Constitution? This I hope you all know. So here I will talk about the directions which were issued to the magistrates for Section 63. So the directions issued by the magistrate for the Section 63 is service of summons on corporate bodies and societies. So these directions you should know. First, you write down. So what were the directions issued here? Whenever a person is arrested and taken into custody by the police without a warrant, he has to be immediately informed of the grounds of his arrest as required under Section 50. You remember here what landmark judgment of the Supreme Court was? D.K. Basu's judgment. So here, basically, those guidelines were applied to all the police stations because that is the that comes under the fundamental right of Article 50. So moving further, let moving further, I told you the judgments. There are three judgments which talk about the directions which have to be issued by the magistrate, and particularly when we talk about the provision of arrest. The first judgment is Sheila Barse versus State of Maharashtra. Sheila Barse versus State of Maharashtra. Second judgment, write down Amrik Singh versus State of Punjab. Third judgment, Jani Janki Prasad versus State of Haryana. So here the directions were issued by the Honorable Supreme Court to the magistrates when we talk about the provisions of arrest in criminal procedure. So what are the directions? The first direction is whenever a person, so never forget the basic fundamental judgment of D.K. Basu when we talk about uh, provisions of arrest as per CRPC. So the first direction was whenever a person is arrested and taken into the custody by the police without warrant, he has to be immediately informed of the grounds of his arrest as required under Section 50 of the Criminal Code. Because this is a fundamental right. Yes, you cannot keep anybody in custody. See, police custody is the worst custody one can ever expect in life. And these fundamental rights, because why Article 21 is invoked here? Because we talk about the freedom of personal liberty as enshrined by our Constitution of India. So the first now all these guidelines which I am talking here in these three cases, they were already founded in one of the landmark judgments of Honorable Supreme Court, which all of you must have read. That is D.K. Basu's case, right? So the second direction was whenever a person is arrested by the police will give intimation of the fact of such arrest to legal aid cell or district concern. Third guideline was whenever any illegal detention is brought to the notice of the session judge by any other person, the session judge of district shall make a surprise visit to police lockup to find out whether any person is detained in the police lockup without being produced before the concerned magistrate in contravention of Section 57 of the Code of Criminal Procedure and the constitutional provisions contained in Article 22. Another landmark judgment which I want to share with you is Rajesh Yadav versus State of UP. Rajesh Yadav versus State of UP. Now here again I talk about 309 of CRPC. Here the directions were issued to the trial courts to make endeavor to complete the examination of the private witnesses of both chief and cross on the same day as far as possible. The trial courts were further directed to take up the examination of the private witnesses before the proceedings with the before the proceedings with the official witnesses. Now, the next case I've already discussed when I had shared the first video with you regarding the protection of vulnerable witnesses. You all remember that case, Samruti Tukaram versus State of Maharashtra, where scope of VWDC, that is the compensation scheme, was expanded for other jurisdictions, including civil, family courts, divine justice, and even the children's courts. Another case which I deem fit to discuss with you is of Suresh Chandra versus Ajit Singh. So here it talks about basically the sentencing powers of the courts. So this court said, the Honorable Punjab and Haryana High Court said that the court at first instance, while avoiding multiple sentences of imprisonment in a trial, must specify in clear terms as to whether the consequently or concurrently, and in case they were to run consequently, the order in which they seem would run. So the order has to be clear. These are the conditions which were These were the conditions which were laid down by the Honorable Punjab and High. Last two more cases, last but not the least, Rajbir versus State of Haryana. And next case, Sakina Begum versus State of Haryana. So Sakina was basically, this case was basically for the vehicles which are untraced. What were the directions given by the Punjab and High Court? So you see in motor vehicles at whenever the accident case is there, you still go to a lot of police stations. You will see there are discarded vehicles. They are just laying there over for more than a decade. So these directions were basically passed by the Honorable Punjab and High Court how to deal. So that is all for today, and I hope you will take benefit of this lecture. Thank you. We will have our next session in this week. And kindly join. You can see all the videos in our YouTube channel also. All the best. God bless you all.